Hi, this is William Brown from Brown, Quan and Lamb. Now that New York is starting the process of reopening after the worst of the COVID pandemic, at least here in New York, I've been getting a lot of questions from people regarding what protections employees might have now that they are going back to work if they or a family member start exhibiting symptoms of COVID-19. So there's actually two laws that employees may have at their disposal if they run into such a situation. The first is a recent law called the Families First Coronavirus Response Act, or the FCRA. And this law provides for paid leave of up to 2 weeks for employees who exhibit symptoms of COVID-19 or who fall under a mandatory quarantine order. It also provides 2 weeks of pay at 2/3 pay level for employees who have family members that they have to care for who are also exhibiting COVID-19 symptoms. This law also provides up to 10 weeks of pay for employees who have worked for their employers for more than 30 days in situations where they might have to take care of a child whose daycare or school has closed as a result of the pandemic. Now, what's important to note is that this law only applies to companies with less than 500 employees. So if you work for a very large employer, this law may not apply in that situation. However, there's another law that may apply, and that's the Family Medical Leave Act, or the FMLA. It's a much older law. And this provides for a certain amount of unpaid sick leave if you or a family member fall ill. What's important to note for both of these laws is that there are certain notice requirements, and that you must provide notice prior to being able to take leave. The notice requirements are a little stricter for the FMLA than for the FCRA. However, under both circumstances, it's important to give advance notice to your employer. Now, there are protections to employees who are retaliated against or terminated as a result of taking these job-protected leaves. So if you're in a situation where you had a family member who fell ill and you took off some time and were terminated as a result, or if you started exhibiting symptoms and you were terminated, you can most likely file a claim under one of these laws, and you should consult with an attorney right away.